Well, it's 12 o'clock here in the East Coast, so we'll begin the webinar. We know folks are still joining, and so we'll just do our introduction. So we want to welcome you all to Animal Law 101 for Scientists. My name is Kathy Hessler. I'm the Assistant Dean for Animal Law at GW Law School, and my colleague is Elizabeth Baker, who's the Director of Research Policy at the Physicians Committee for Responsible Medicine. So what we want to talk about today is this webinar is part of a series of webinars that we'll be doing through the Animal Law and Science Project here at GW. And that project is guided by GW Animal Law and Dr. Lori Marino at the Camilla Center. So we'll be offering a series of webinars that are focusing on the intersection of law, natural science, and social science to introduce lawyers to the impact science has on law and scientists to the impact law has on science. And the goal is to help us all work better together to achieve our goals. So we'll be having different experts from scientific and animal law communities as we go forward. And we're doing overviews right now, and then we'll be doing a series of webinars that focus on really specific and targeted topics. So starting with Law 101. Some of our goals are to help enhance legal literacy as we're working across professions with our scientific colleagues. We want this to be a conversation starter, helping people know about the field and learn that there's a lot more to learn. So Elizabeth and I are doing a really sort of 30,000-foot overview today, and we can't cover everything. We certainly can't cover it in depth. So we want people to know there's a lot to think about. So we want people to also understand there are a lot of pitfalls in working with the law, a lot of misunderstanding about its capacities, and in order for us to be able to work more effectively together. And so again, we're going to be talking about large scale concepts rather than a lot of detailed content today. Okay. So the overview, I'll be talking about litigation issues, and Elizabeth will be talking about lobbying. Some of the questions that brought us to this work, why we decided to go forward with this webinar series, the fundamental question was we saw problems with scientists not understanding law, lawyers not understanding science, and having bad outcomes. And so we asked ourselves the question, what would a legal system properly informed by scientific understandings about animals, the harms of their usage and so forth, look like? What would that look like? And then how, of course, do we get there? And so our desire is actually to protect animals from harm. We're assuming that's sort of a baseline conversation with our audience, and that may not be true, and that's fine. But scientists can help lawyers meet their legal burdens, help them understand how to use the scientific evidence to do that. And we can be asking ourselves whether legal decision making is based on good science and strong findings. We can ask what are the rules of the legal system, and we'll talk a little bit about that today. What would be helpful for scientists to know about the legal system? What are the limitations of legal advocacy? And what are the differences in ideas and approaches between scientific and legal professionals? So those are sort of the larger scale questions that are informing the work that we're doing. So law and science really generally, people mean different things when they say law and science. When they talk about law, some people talk about just one kind of law, and science just one kind of science. So we mean those terms really, really broadly. So the overlap of law and science really is everywhere, but we're not trained or used to seeing it. So part of this work is designed to help us see it, to recognize it, and then obviously to do it better. And so I thought I'd start with an example that is a non-animal law example that's been in the news that might really help people understand the breadth of what we're talking about. So people are probably familiar with the Alaska Air situation that just happened recently, where the door plug of a Boeing plane came out of the plane at 16,000 feet, which created obviously some significant problems. So it raises immediately for lawyers the question of liability, right? And the answers about liability require some scientific information to assess those questions, right? So the question about liability generally, with respect to Boeing with its customer Alaska Airlines, and the National Transportation Safety Board, because there's a government entity, this is a regulated industry, and with respect to Alaska Airlines and its duties to its customers and also its government responsibilities. So we need scientists to help answer these questions. So we need engineers, different kinds of engineers, structural engineers, design engineers, to help determine what happened and what should have happened. We'll be looking to hear from medical doctors about the physical harms that occurred to the passengers and crew. We'll be looking to hear from psychological experts about the trauma, the mental and emotional trauma, and those kinds of injuries. There'll be economists and financial experts providing evidence about economic damages and so on. So this is just one example of one legal issue that requires a lot of scientific and professional expertise in order to answer the question about what happened, what should have happened, and what goes on, what goes forward from here. So that's one example, and their animals are ubiquitous in our society, and so is our use of them. And so there are innumerable examples of the overlap between human and animal contact that creates legal questions. And there's also a really wide variety of scientific questions that will be brought to bear on answering the legal questions, because our lives are entwined with them in innumerable ways. So lawyers need the work of scientists across many disciplines to understand and to help judges and juries and legislators and regulators and lay people understand who animals are, where they are, how they're being used or abused, what harms they suffer, and then what we should be doing about that. So the last sort of prefatory information that we need to be thinking about is the animals themselves, because we don't even know sometimes which animals we're talking about and what beings count as animals. Because as many of the legal folks in the webinar will know, not all animals, biological animals, are deemed animals in the law. And so when we talk about animals, we actually mean all of those animals, even the ones that we don't recognize as animals. I tend to use the coral example with my students, and not everyone understands corals themselves are animals. And so if we don't know who the animals are, we can't be making explicit decisions based on good science about how they're used and how they should be protected. So those are our sort of starting places. And from there, I'll begin to talk about some litigation. So an overview about what we mean by litigation. And again, a reminder, this is a sort of 30,000 foot view. So it's going to be really basic for people who are familiar with this. So basically, litigation is a method that we have in our society to resolve disputes. And so it's used in different ways and in different contexts. It's not actually, as some people think, designed to determine truth of the whole matter, right? It's designed to come up with an outcome that is some approximation of justice, hopefully, but not necessarily justice in a larger sense. And it's a context in which we focus on what can be proven, right? And so that's affected by the amount of money that the parties have, the availability of expertise, and so forth. And the sides are certainly not tending to be equal. So one side that has more money or more expertise or access to other resources may win because of that. And it doesn't mean that that's necessarily correct. But that's an outcome that we have sometimes in litigation. And so the goal of litigation is to assess liability or culpability. So whose at fault, whose fault is the issue, and who's responsible for the behavior, what harm flows from that, and then what damages result from that harm, and who gets the damages. The law can't, and litigation can't undo harm. It can sometimes mitigate by stop ongoing harm, but it can offer damages for harm that it has assessed has happened. Litigation is also an adversary system, and when we're talking about science in particular, sometimes people talk about it as a battle of the experts. So this side has one expert that says X, and another side has another expert that says Y, and how do we decide which expert wins the day? So we'll talk a little bit about that in a moment. The other thing to know about litigation is that we're not seeking scientific certainty or the level of certainty that for our evidence and proof in a litigation setting as we would be having in a courtroom, right? So there is evidence, there is proof, but we're not talking to a scientific standard, okay? Okay, It's good to know that there are multiple jurisdictions that lawyers and scientists work in. So in the United States, we have federal, state, local, and tribal jurisdictions, and there are also international and foreign jurisdictions. Because animal law concepts are ubiquitous again, we have animal law issues across all of these jurisdictions. But each jurisdiction has its own rules for how litigation functions. Some of those rules are written, some are unwritten. Those are the harder ones to ascertain in advance sometimes. And how much and what evidence, what kind of science comes in is different in each of these jurisdictions, how it comes in, what comes in, and how it's used once it's in. So the rules for experts can vary across jurisdictions. How much information sides need to share with one another, that the rules for that, and the guidelines for that change jurisdiction to jurisdiction, and the timeframes upon which all of this has to happen also changes from time to jurisdiction to jurisdiction. When you know upfront what those rules are, so if someone's asking a question of a scientific expert, it's good to know, well, what jurisdiction are we talking about? What context are we talking about? Because then you have a sense of how you can answer that question sort of more efficiently. So attorneys will be asking scientists and do ask scientific experts for their input about what information is available to prove their claim. If they want to say this animal is harmed, do we need to show the harm? What are the scientific studies that show this is a capability that the animal has and it can be harmed in these ways? And when that harm exists, here's some of the outcomes, right? So what is that evidence? Where does it exist? And how is it going to be able to come into court? Scientific experts also can understand what information the other side is going to be presenting and try and point out weaknesses in their arguments or their reliability of their experts or their data. And so what works in one jurisdiction may or may not work in another. The different kinds of proceedings that we have in litigation: civil proceedings, a situation where people bring their claims to address harm. So that's individuals, companies, governments, nonprofit, private companies, saying somebody did something that we want to stop, or they did something that caused harm that we want to address. And the defendants in those cases seek to deny or minimize their liability. In a criminal setting, it's the government bringing the cause of action, claiming wrongdoing on the part of the defendant. Animal abuse is a sort of a typical or example. So if the government says someone has abused an animal, then the parties to that case are the government and the defendant who's been accused. But the victim or the human being seeking to protect the animal victim, they don't have a formal role in a criminal setting. And so it gets a little complicated. Some jurisdictions do allow more or less involvement of people in the victim role. So we have the civil and the criminal type proceedings, and then we have administrative proceedings. And so those are typically a state or federal agency. And again, the government would be a party to that action. And that can be bringing or defending a claim. And there's a question right now about how much deference we should be giving to agency decision-making. That's a big question that we can talk about later. But it's good to know that in an administrative hearing proceeding, there are usually less formal rules than there are in a civil or a criminal proceeding context. Okay. So the timing of how we end up talking about these things, when is science needed, right, in these proceedings, in these settings and jurisdictions, in a number of ways is the answer to that question. So we need the science before cases are even filed. So using scientific experts as consultants has become a larger and more important part of the conversation, and it's really, really useful. So if a lawyer is thinking about bringing a case, talking to a scientist first, having a consultation and saying, do we have science, right, that supports what we think is the reality here? How would we frame the case so that we can showcase that science and so it can support the claims that we want to make? So consulting, and sometimes I know situations where scientists have said, yeah, no, we understand what you're trying to do, but there's just not data to support your claims. So you can still make the claim if you want, but you're going to have to deal with the fact that there isn't data that's going to be scientifically valid that you're going to be able to use. So consulting, very important, and that can happen all the way through the litigation phases. Um, the scientists can also help frame a case and say, like, this is, if you explain it this way, this will be helpful. And they can help write complaints and briefs, meaning, draft certain sections where the science is important, or guide the drafting of those, along obviously with attorneys, not violating any ethical rules. They can predict and address what the likely opposing scientific arguments will be, or the science that the opposition will rely on. And so in that case, the plaintiffs often set the timing. So there's sometimes plenty of time to kind of do all this work. Sometimes there's not. After a case is filed, the timing is set and controlled by the court. So there's less wiggle room there. And here, scientists, if they're coming in at that point, they're usually adding support for the case on one side or another and critiquing the other side. So scientists can also be really helpful in drafting, framing briefs. And so sometimes those are things we call amicus briefs, which are friend of the court briefs, which are entirely separate. They're not guided by the lawyers bringing the litigation. They're usually done in consultation or collaboration, maybe or they could be done, it could be briefs that the lawyers need for a phase of the litigation. So if a hearing is coming up and there needs to be a specific briefing on the science on a particular issue, then that can happen. Those windows are much, much shorter. The shortest windows for scientists to sort of get involved are in matters of injunction. And that's when a court's saying, somebody is petitioning a court to say something needs to stop immediately because there's harm that's happening. And those are very, very short windows, so a matter of days or weeks. And you do see these cases sometimes arise in cases of animal abuse, where either someone's petitioning to get an animal out of an abusive situation, or there's harm to, say, wildlife or something like that that needs to be stopped. And so scientists are very helpful in those situations too. So the standards of review in a judicial setting, right, in litigation, is different than the standards of review in the scientific realm. In the law, we basically need enough information to make a decision for the particular case. Judges and juries are not making decisions for all cases, not even all similar cases, right? Sometimes they are setting a precedent for similar cases, but they need to make the decision for the case that's in front of them. And that, again, is a little bit different than a scientific mindset. In the civil context, the standard of review is what's called preponderance of the evidence, which is really sometimes difficult to explain because it needs to be greater than 50%. So more likely than not that something happened or did not happen. So it's not anywhere near the scientific standard of evidence or review. In the criminal context, the standard is beyond a reasonable doubt. So there, the evidence needs to be so strong that there's no reasonable doubt as to guilt. So that's much, much stronger. It may be a little bit more akin to what scientists are used to. In the administrative settings, there's two ways to think about that. So how do administrative agencies decide what is the standard of review for them? And once they have made a decision, when in a litigation context, a judicial body is reviewing what they've done, what is the standard there? And so we have reasonableness and substantial evidence on one hand. We have arbitrary and capricious, meaning we're gonna allow what the agency said. We're gonna give them deference unless what they did was arbitrary and capricious, which is, again, not akin to a scientific standard at all. And so it's also useful to attend to, I'm saying, judges and juries. So the decision makers in a litigation context applying these standards of review are judges in some cases, or juries, or both in some cases. And it's also really important to note that not all juries need to be unanimous, which means that some people are going to decide a standard of review has not been met, and yet they'll be going forward because the majority of the jury will have decided differently. Again, different than the scientific community. Okay, so getting science into the courts, scientific evidence comes in through experts. And so those experts need to be certified as experts, and there's a process for going through that certification. And the information that's coming in, if it's going to be labeled as expert, also needs to be identified that way. So in 1923, the comment standard that courts used was established, and that was called the Frye Standard, which just said is this generally accepted in the scientific community? And if it is, then it counts and it comes in. In 1993, a new standard was developed that's used across all the federal court system and in many state courts as well. And here you see the list of factors. So whether the expert's technique or theory can be tested and assessed for reliability. So all of these have to be answered in the affirmative. So yes, if the technique or theory has been subject to peer review or publication, if what is the known or potential rate of error of the technique or theory, the existence and maintenance of standards and controls, and whether the technique or theory has been generally accepted in the scientific community. So if you can pass all of these elements, then you as an expert or as a scientific expert or the data can be entered into the court under the expert label. Okay, so once the science gets into the court, how do the courts use that science? So they weigh scientific evidence along with other evidence. And again, the people weighing this evidence are judges and juries who decide for themselves how credible this evidence is, which to accept, which to reject. And they do that without a scientific background. And even if they have a scientific background, likely not relevant scientific background to what is needed in any particular case. So this is a different use of scientific information than scientists are used to. So the types of science in courts, so we have testimony of experts. So sometimes there'll be firsthand knowledge. So a veterinarian who had cared for an animal can testify about the harm and the physiological damage to that animal and what they thought maybe caused it or what follows from that harm. Other people can testify about their knowledge generally as an expert in the field, so professor, scientist, or researcher, that kind of thing. There's also documentary evidence, so the submission of x-rays, tests, studies, scientific studies more generally can be, there can be documentary evidence along with that, or they might be separately introduced into courts on their own. And as I mentioned before, there'll be competing experts and disagreements that will be presented to the judge and the jury. And they're seeking to undermine one another and the testimony generally that has been presented. And at the end of the day, it's up to the judge or the jury to decide what to do with all of that information. Okay, in legal settings, the role of scientists, this is sort of at the heart of what we're hoping to start more conversations about. So again, addressing the harm to animals is sort of our baseline, but within that, there's lots and lots of roles for scientists within the legal setting. And so this, I'm talking a little bit within the litigation context, but it's obviously broader than that. So scientists can be witnesses, so they can again testify for court or hearing in a formal proceeding. They can be an expert signatory or author or contributor to a brief, amicus brief or other kinds of briefs. They can help attorneys and parties understand and present scientific information, again, while that's developing the case or in court in settlement discussions, sort of any aspect of the litigation process. And this, I think, is something we don't talk about enough. They can help the judge and jury understand information and standards. So the lawyer's not always the best at conveying scientific knowledge and breaking it down into terms that the decision makers can understand and utilize, implement, right? What do they do with this information? So it's useful when lawyers and scientists are deciding to work together to be clear about the roles and responsibilities up front. What is it that lawyers are asking for the scientist to do? What are they asking from them? And sometimes the lawyers don't even know the right questions. They don't know the breadth of the scientific information available or the limitations. They'll see a study and say, oh, this looks great, let's use this. So trying to get that clear who has different sort of responsibilities in the conversation. That definitely helps. And so that translation of science for people in the legal context is really the most important thing that scientists are going to be doing. The language that lawyers use and the language scientists use are very different. So there's an immediate translation need. Lawyers tend to use scientific language poorly, right, historically. Lawyers want to say things like, well, the science shows or the study proves. And that's overstating or simplifying the strength of support or findings, right? So they tend to say it incorrectly, inaccurately, because they're trying to make sense of it and then apply it in a legal context. They tend not to confine the findings of within the context, right, of a study framework. And so they'll apply something that has been shown in one context, and they'll say, well, it applies in another context, and they'll do that inaccurately, not understanding the limitations of that initial study. And so because scientists and lawyers use jargon, right, we're using language that is effective for what we want to do, but it complicates good communication across these professions and certainly to lay people. And that makes actual communication challenging. And it's useful to know that lawyers and scientists use some of the same terminology, but mean very, very different things. And this takes a lot of work for lawyers to kind of break it down and understand so that we can then do it more effectively when we're having these communications. So something like risk analysis or harm or certainty, these are principles that occur in both law and science, and there are many, many others, but they mean different things. They may have different standards. They have different processes for determination or application. And so trying to figure out where are we using language that we think we're using the same words the same way, but we're not. And that's a process of discovery that is really important for lawyers and scientists to work through together. Also, it's really useful when lawyers are talking to scientists to understand that our ways of thinking and being are sort of fundamentally different in some respects. So the scientific process is about questioning and exploring, and reaching consensus isn't the ultimate goal. And in fact, in some areas, scientists say we can't really ever get a full consensus or a full definitive answer that we have finally and authoritatively and once and for all proven a particular point. That's not sort of how science works. It's always evolving. Whereas lawyers are like, no, I need an answer. I want to know if I can prove this point legally and be done, right? That's so I just need enough data applied in this context so that I win my case. And understanding more about how that legal decision-making process works in litigation is really useful for scientists. It's useful for lay people, and many people, when they realize how it works, they get somewhat upset, right? So you can have a decision without evidence, right? You can have a decision with the available evidence being contested, and you can have a decision without opposition evidence being presented. So in things like default judgments. So it's not at all the process of sort of an even-handed process of discovery that scientists are used to. Okay, so this is where I'll stop, and I'll invite back my colleague, and she'll talk about the lobbying.
Great, thank you so much, Kathy. Next slide, please. Hey everyone, it is so nice to be here with you today. Over the years, I've learned that many scientists are feeling really intimidated by the thought of lobbying. So with my quick talk, I'm really hoping to demonstrate that it's not such an intimidating thing at all. I want to demystify it a bit, show you hopefully that it can even be fun. And we'll look at it through the lens of how scientists might expect to lobby. So what should scientists consider? What are some of the things that scientists might expect to do? We're going to look at what lobbying is, who does the lobbying, who is lobbied, how to go about it, why to do it. We'll take a quick look at federal and state lobbying, some of the differences. We'll dig into legislative activities and non-legislative activities, and then we'll take just a quick glimpse at agency lobbying, and then we will wrap up. Next slide, please. So what is lobbying? Let's start with thinking about what it is, who does it, and what it looks like. It really just means at its core, working to influence policy. So this can really just take the form of meeting with your relevant officials or policymakers to provide your perspective and your expertise and to make a request. I know that some people tell me sometimes that they think lobbying is like a bad word. And I really hope to share that it doesn't at all need to be a bad thing. It can be as simple as you, somebody who knows something about an issue or has a perspective on an issue, providing that perspective or that expertise to a policymaker. And successful lobbying, it really requires building and maintaining relationships with policymakers. And so Sometimes I see it as different than litigation, where maybe where you're kind of on two sides of things and at odds with policy. Sometimes it feels like, putting your arm around someone and bringing them along with you on an issue. So who is it that lobbies? Of course, you have professional lobbyists. And I think this is what a lot of people think about when they think about lobbying, the people who are hired to influence legislation, regulation, or other government decisions. But they're not the only ones that lobby. You have individuals, and then you have organizations lobbying too. And so, for example, I'm not currently a registered lobbyist. I have been in the past in states and the federal government. But I do lobby still in my job now. So it is important to be aware that there are some registration requirements in. So you want to know in your jurisdiction where you lobby what those are, because once you get to a certain threshold, those registration and reporting requirements would be triggered. For the federal government, the requirement to register as a lobbyist would be triggered if you spend more than 20% of your time on federal and agency lobbying in a 3-month period. So I wanted to briefly mention it just so people are aware, but I really don't think it's going to be an issue for most people here, because I'm guessing that the majority of those that are interested in this as a 101 topic are interested in doing a small amount of lobbying in support of their work and their interests. So scientists can and do lobby. And I think a lot of I think scientists have really contributed to a lot of the achievements that we've seen for animals in recent years. Now, the work that I do focuses on moving away from animal use in research and testing. And so if I might seed in some examples along the way, and they'll be based in that. But just one general idea, thinking about a law and how scientists have played a role in getting there. Several years ago, a law was being lobbied on. It was called really TSCA reform. We don't need to get into even what it stands for, but what it is important is it marks the first law in the United States that requires a federal agency, the Environmental Protection Agency, to use and develop non-animal scientific approaches. And when this law was being lobbied, we had staff scientists and policy experts that lobbied members of Congress. And then we were also often accompanied by scientists with specific expertise. So let's set the stage for what you might expect to see in a lobbying meeting. Scientists really can expect that you're just face-to-face meeting with people. So it's either in person or still virtually. You can do quite a bit with congressional offices or federal agencies, and you're just really there to discuss an issue. So that's going to include what you want the member of Congress or that agency to do about the issue. When you're lobbying federal Congress, you should expect that you're going to meet with the staff of the member of Congress, including a legislative aide or their staff that cover health or animal welfare issues. The meetings are going to be about 15 to 30 minutes of discussion. It's rare you're going to get more time than that, because these offices and their staff are just booked with back-to-back meetings. And a meeting with a member of Congress themselves is going to be a lot more rare. So don't be insulted if when you go to your lobbying meeting, your member of Congress doesn't show up. It's actually the norm that you're going to meet with office staff. Don't go in expecting a debate. Really, it's a conversation. And I think that it helps to remind yourself that you know more about the issue than the person that you're talking to. So it's so important to have scientists involved in lobbying, because you have these Hill staff that are covering so many issues, and they're relying on the people that are lobbying to provide expertise on the topic at issue. So your goal is get them interested, get them to act, get them to utilize you as a subject matter expert. You can build your relationship so that when something relevant crosses their desk, they're going to reach out to you to get your perspective and see how you think about it as they decide how they think about it and what action they might take. And then likewise, when you're working on an issue, you'll be able to go to them and ask for their help in advancing that issue within Congress. You're going to need to follow up. There are a lot of issues and asks that come across their desks. And so you just got to be persistent. And that goes for working in federal lobbying, state lobbying, with agency lobbying, just all of it. You've got to understand they just have tons on their plate. And so you're going to need to follow up. Just one little tip before we move on. I have found that when trying to get meetings or to even follow up to keep your discussion going, offices and agencies, they're just so busy. And because they're getting so many requests, have a very descriptive subject line and have a short email. It's really helpful for getting a response. Next slide, please. So it's important to decide who are your relevant members of Congress that you're going to lobby. So members are going to expect to hear from constituents that live or work in the area that they represent, as well as experts and those with information on issues that are important to that member, and then also on issues that are relevant to congressional committees in which the member of Congress participates. So scientists that are interested in lobbying should really first consider who are the members of Congress that represent you in the area where you live and work. Sometimes it's the same, sometimes they're different. These members of Congress are going to have an immediate interest in hearing from you and what you seek. When I started lobbying, I found this really surprising. I didn't realize that people would expect to hear from me or even want to hear what I had to say. I kind of expected I was going to have to go in there with this big sales pitch and get them on board with even listening to me, but that's really not the case at all. They're elected by us, and it's their job to represent us. There are already a lot of members of Congress that are interested in animal and science issues and the overlap, and a lot of them have already engaged in work that can help advance science without animals or to better the lives of animals used in science, for example. And these members are going to be interested in meeting with scientists that have a perspective to share, whether or not you are a constituent. So it's not going to matter, do you live or work in their area where you might vote for them? It matters that you have something to say about the issue. And I was just thinking about, if for scientists who want to start lobbying, I think that one easier way to, if you're new to it, to identifying who to lobby and kind of the process and getting your feet wet, is to partner with NGOs or with organizations that are already lobbying. You know, I work at an NGO. We love taking scientists to the Hill to support our asks. I know companies feel the same way, other organizations feel the same way. So I think there are a lot of opportunities for people who are interested. You just really have to build your network, even just among the people who are lobbying already. But you don't have to do that. You really can go in as an individual and talk with a member about what you want to talk about. So you also have members of Congress that are sitting on committees that consider bills and issues. They oversee agencies or programs and activities within committee jurisdiction. And so those members are going to expect to hear from people who are working on issues that are being considered by the committees that they sit on. And then another great way to identify and to build your congressional contacts on an issue is through congressional briefings. So briefings are just events that focus on a specific topic, and they often are going to include an introduction to an issue, a specific ask of Congress, and you're going to have multiple subject matter experts that present short presentations that justify the need for congressional action. And so these briefings are often organized by policymakers or a group of scientists and organizations that work with a member to host a briefing. And they really help you identify offices that would be interested in working with you on the issue. Scientists are frequently invited to present at these congressional briefings. And so I think if you're interested in that, again, reach out to the many organizations that work to host these types of briefings, which are, of course, ones that come to mind for me are NGOs, trade groups, and companies. And see how you can work with them to be able to get your information before Congress. Next slide, please. So I want to touch on federal lobbying because you can make just such a huge impact for animals through both federal and state lobbying. But there are just, there's some differences between the two, but federal, of course, is going to be affecting all of the US. And you have many members of Congress. You've got your United States Congress making up of the Senate and the House of Representatives. You're going to have 2 senators per state, and then representatives are going to vary based on population. But among the powers that these members of Congress have are passing laws and directing spending. And both of those things benefit so much from engagement from scientists, especially when you're trying to use science and law to protect animals or to advance science in a way that moves away from animal use. I think there's a lot of opportunities. And I'm going to provide some examples in just a moment of some federal examples, but I want to quickly, next slide, talk to you a little bit about state lobbying, because you can make a huge impact at the state level as well. The state, of course, is going to be affecting the citizens of the state or the activities that are taking place there rather than the whole US. A lot is going to be similar in terms of identifying your members of Congress, what your meeting might look like, just what do you expect. But there are differences state by state in what they consider lobbying, what triggers lobbyist registration and reporting requirements. You might have different committees. The divided legislatures could be called different things. There's different processes. So the specifics can be different, but as a whole, I think it's fairly similar. One example for how you might work on the state level, I'm thinking of a law that I worked on with a wonderful group of people in California several years ago. We were trying to make California the first state to ban the sale of cosmetics that are tested on animals or for the final product and the ingredients. That law did pass, and scientists played a pivotal role in that. So we had scientists that were coming to the lobbying meetings with us to drum up support for the bill. Scientists testified in support before the committee. They also did press and media days. Next slide, please. So I want to dig into some legislative activities. So these are bills, proposed legislation, draft amendments, specific policy proposals. And I think that this is what people really think of when they think of Congress. It's passing laws. And there are a lot of opportunities for scientists to engage in this legislative process. And a lot of them are recurring. So it's once you get to know them a little bit, you can expect what's coming in the future. But then additionally, scientists can lobby with members of Congress to introduce legislation or in reaction to a bill that would either positively or negatively impact science and animal use. So I want to dig into appropriations a little bit. I think people are familiar with the term, but don't always know exactly what it means. So Congress passes appropriations bills annually to provide federal funding to federal agencies. And these appropriations bills include spending instructions, directives, expectations, and restrictions for how the funds should be spent. The timing of appropriations varies year to year, but you could expect if you're going to be lobbying on appropriations that it could go from about early February to end of September. It's not a foolproof system. Case in point, this year, appropriations have not wrapped up yet for fiscal year 2024. But during that process, when you are lobbying, you'll just meet with different members of Congress and you're going to ask them to support whatever funding request you'd like to see in that legislation. There are certain members of Congress that are part of appropriations committees, and those committees also have dedicated staff that are going to expect to hear and take requests from experts during the appropriations process. So you can be lobbying the members, but you can also lobby the committees and the committee staff as well. And through appropriations, scientists are going to be asking again for providing or restricting funding of certain activities. And then you can make additional accompanying requests in report language. One quick example that for appropriations, our team lobbied Congress for a few years trying to get the FDA funding We were seeking $5 million for the FDA to integrate scientific approaches that could both improve outcomes for humans and reduce animal use. And the FDA actually ended up requesting 5 million as well. And Congress provided it at the end of 2022 for the purpose of reducing animal testing. So along the way, scientists, our scientific staff and policy folks were meeting with the appropriations committees and staff, but we were also bringing in outside scientists to join us in those meetings. And just one really cool thing, just I think that can demonstrate how much impact you really can have when you might feel like, what is my voice in this huge world of lobbying? But after Congress gave FDA that money, we had this awesome moment where a congressional staffer told our team that our joint advocacy on the issue strongly influenced Congress providing that $5 million to the FDA for the purpose of reducing animal testing. So that's just one example, but I know there are so many from other organizations and scientists as well, and I'm hoping to see many more in the future. So we also have reauthorization bills that I think are a good thing to be aware of. You have authorization bills that authorize activities of federal agencies, and some of those authorization bills they have to be reauthorized on a recurrent basis, such as every 5 years. And so that means that Congress really is going to have to pass the law every so often to allow those certain authorized activities to continue. And it can be tough. I think a lot of people know it's hard to pass a law in our federal Congress. So scientists really, I think, should consider linking your request to this must pass legislation, because that has shown to be a good idea in the past, and I think it'll prove fruitful in the future as well. So we have proactive and reactive laws, is kind of how I think about it, but really any member of Congress can introduce a new bill. As a scientist, you can work as an individual directly with a member of Congress on ideas for a bill that would establish legislation on a new topic, or bills that would amend existing laws, or you could work, of course, with other groups or coalitions of groups. And then you have the reactive laws. So sometimes bills are going to come up that contain provisions that, if passed, would be harmful to animals used in science, or maybe they would increase animal use, for example. So in these cases, scientists can lobby the members to communicate the negative impact and why the member of Congress, say, could work against the bill to stop it from passing. Next slide, please. There's a couple of non-legislative activities I want to cover quickly because they can be really impactful too. So Congress isn't just passing laws. There's all sorts of things that they do, but I have seen a lot of impact from scientists working on congressional inquiries or sign-on letters. You might hear them called different things, but essentially it's just a letter that is sent from a member of Congress or a group of members to an agency that is going to request the agency take an action or provide some information. And these inquiries can be really helpful for obtaining information that's difficult to get from an agency directly. And they can also really help you build congressional interest in working on an issue that could eventually even lead to legislation or more partnerships. So for these letters, scientists often are providing their perspective and providing information that is then used in the letter as background for whatever request the Congress is making of the agency. And then another idea, you can invite your member of Congress to see your lab and your facilities. I think people are surprised to understand that members are really proud of what's happening in their area. Get them jazzed about your science and capabilities and supporting your needs. And I think this would be just something really great that people can do now and with ease. Next slide. I'm going to wrap up quickly with agency lobbying. Agencies issue regulations and they want comments on them. This is a really good way for scientists to be involved. You have the Federal Register that comes out, and updates come out every morning that are telling you what are the agencies doing. And so we have scientists on staff, and I know other scientists do this individually and at other organizations as well, where you monitor what the agency is putting out each day. So just on our staff, we have someone who is monitoring EPA activities. He knows the law so well, but he also knows the science, and he will review everything to ensure it's in line with the law that requires the agency to use non-animal approaches. So he can write up a comment, submit it for the agency to review it. And, if we don't have that, if we don't have all the information that we need, we'll partner with scientists to make sure that we provide it. So that's it for me. A bit of a whirlwind of lobbying, but thanks for being here and thanks for listening. And back to you, Kathy.
Thanks. So we're going to wrap up here. We just put a few questions going forward that we don't really need to kind of go through. Just sort of what should we be thinking about? What should we be studying? Questions we should be asking? What lenses should we be using as we continue to do this work? And so I also want to mention that we're going to be building sort of access to resources and having a repository. So these slides in this webinar are going to be some of those resources. They'll be posted on the Animal Law and Science Project section of our Animal Law Programs website at GW. And so if there are things that you would like to see included as resources, or you have suggestions or things you want us to find and add, then just let us know. Okay. So with that, we can end, and thank you for your attention and open it up for questions. I'll also note that our next webinar will be on February 7th, the Natural Sciences for Animal Lawyers. So I will stop my screen sharing, and we can, well, actually, I'll leave it on this screen, and I'll look at the questions that we have. So the first question was about slides. So yeah, we're definitely going to have access to the slides. The second question, actually, both second comments were just thank yous. So are there any questions? I know we went through stuff very quickly and we did it as an overview. So a question from Joe Anderson, is there a database of scientists who are willing to be called on for any kind of the work that we're discussing, the lobbying and expert witnesses? So right now, we're not aware, I'm not aware of a database, but part of the work of the Animal Law and Science Project, hopefully, is to be developing conversations. And so it's something we can take on and see if we can kind of create that resource. We also have an Animal Law and Science listserv, which has been pretty quiet recently, that folks can have some of these conversations, share information and resources. We share there a weekly update of events, conferences and symposia, that sort of thing, that people might be interested in this area. So it's a great question, and it's something that I think would be helpful. It's on our sort of our near future, maybe, to-do list. Yeah. So let's see, we have a couple of other questions. When you have success like the $5 million funding for alternatives that Elizabeth talked about, how do you follow up with that to understand how those funds have been used? That's a great question.
Yeah, it is a great question. It's something that we've had to learn along the way, kind of the hard way, because there's not a lot of transparency in some federal agencies. And so one thing you can do is you can work directly with the offices that you worked on, kind of behind the scenes, to bring the issue to them who brought it forward within Congress. You can work with them and ask for an update. We've done that in the past where staffers went to the FDA and asked for an update, and they provided it, which was then shared. The other thing that I think is really important when you're working on these requests of agencies is to be really clear about what you want. And so now when we are working, we are asking for public reporting, and you have to be so specific, actually, that if you want to, I think if we were doing this now, it would be $5 million of funding for this, maybe with some guardrails for how that might be spent, and then reporting back that is written and publicly available is what I would request now.
Great. Another question is whether there's a network of scientists interested in supporting lobbying and litigation. Uh, and I think it might be fair to say there's some sort of informal network, but there really isn't a formal one. And I think it's going to, again, it's a resource that would be really helpful for the community and people doing this work. It's a little challenging because, for instance, if I need a scientist to talk about the capacities of an elephant, right, and how those capacities might be interfered with, then I need a scientist with that information and expertise and a knowledge of the scientific literature, and then a willingness or ability to testify or to engage in lobbying. Those are all really narrowing, right, factors. And so that person might be willing to do that kind of work on a regular basis, but not open to just saying, yeah, I'll do any kind of sort of litigation and lobbying. Um, or you might have someone say, I am willing to do any kind of litigation and lobbying in my area of expertise. So there's a lot of different sort of nuances, and it takes time and energy for scientists to learn how to participate in the legal setting. And I should say it's very often uncompensated. And that makes it really challenging. So people are taking time away from their research or their studies or their teaching um, to figure out how to participate and then do actually participate. Um, so it's a good question, and it's something I think that many of us we're trying to figure out a better answer to. And so hopefully this community and these conversations can be the beginning of getting a better answer. I don't know, Elizabeth, did you have anything you wanted to add on that one?
No, I think you did a great job.
Okay, thanks. Um, so we've got a couple more questions. We mentioned harm to animals, but what qualifies for harm isn't always settled through science. Yep, even through animal welfare science. And so how do you envision dealing with such an issue, particularly given the centrality of, say, humane killing as an issue in a number of animal use industries? This goes a little bit, so it's a great question. It kind of goes back a little bit to what I was just saying. It's very specific, it's a very fact specific question. So, which animal are we talking about? In which kind of context? Under which circumstances? And then what's the decision making context, right? So, what sort of standard of evidence do we have to reach to say that harm does or does not exist? Because that's a different standard. If we're talking about lobbying, we can say harm a little bit more vaguely than if we're in a litigation context, perhaps, but maybe even more specifically if we're in a rulemaking context, right? So it really, really depends. The good news is that I think more and more lawyers and scientists recognize that all of these terms are subject to lots of conversation, right? So to evidence, to prove, to disagreements about what they mean and how they're used in each context. So I hope that's helpful. Elizabeth, did you want to add to that?
I I think is maybe more relevant for your work for lobbying. I would probably just choose to stay away from that issue, honestly, and work toward replacement of animal use.
Yeah, so that's also a really good question, or a really good framework for addressing the question because everyone has a really different perspective. And so I think fundamentally, this question should help remind us to ask more questions. So what do we mean by harm? What is the context? Which animal, which capacity what's the end sort of result? And who am I talking to and what is their perspective and maybe their agenda, right? And so how do I then engage in the conversation with all of that information and data? Yeah. Yeah. And so not only is law really sort of variable in science, they're very distinct, but how people in the community think about animals is really, really different, right? So from social or religious or traditional or cultural perspectives. And so again, when we say even animal, much less harm to animal, people hear and think about different things. And that makes our conversation more fraught, but it means we have to do a little more work, right? So some more questions. How often do legal teams commission research for litigation? It's a great question. It's happening more, which is wonderful. But it can only happen with people who have the resources. And so that's increasing, that there are people who are working on animal litigation who have greater resources than they used to and are taking cases, through the system, not just sort of stopping at trial court levels. Um, I think what you see is that the nonprofit organizations that are designing litigation that they intend to be very impactful are very thoughtful about how they create and craft that litigation, and those are the folks who are more likely to commission research. And I should say, let me step back, sort of commission consultation, and that's sometimes like a literature review, that kind of research, but actual research. Is usually commissioned, at least what I'm seeing is commissioned for advocacy efforts, not for litigation, because the time frames don't usually kind of connect, right? So that the time it takes to do research, other than again a literature type review type of research, it's going to take a lot longer than waiting to start than you want, because you're not going to want to wait for that to start litigation. Um, yeah, so that's what I'm seeing. Are you seeing anything different, Elizabeth? No. Okay. Um, okay. So another question, and I know that we're over time, so we're at time. So we'll take these last couple questions, and then we will end. So as a scientist, the question is, how do I find animal lawyers and lobbyists who might need my expertise? So that's a little bit easier to answer, which is great. There are a whole bunch of nonprofit organizations. There's some faculty who have specialized work for animal protection. And so you can just reach out to any of them. Sort of any entry point, I think anyone you talk to can then refer you to other people who might be even more particularly suited to work with your expertise, who might need you. So I think anyone that you ask in the community will be able to help. Does that make sense, Elizabeth?
Yeah, I think that's exactly it. There are so many NGOs that are doing awesome work in many different areas. And so what is your interest and what is your expertise? Just reach out really to any. I think people know each other fairly well within the community and want to see everyone succeed in the work they're doing. So I think you'll find a lot of friendly faces wanting to help you find your place.
Yeah. And then the last one that we have is actually for someone wanting to volunteer, which is fabulous. So we'll take down, Elena, your information and share it with our networks. And you can feel free to join the Animal Law and Science listserv and offer your services that way. And as Elizabeth said, just reach out to anyone you think might be interested. So with that, Elizabeth, on behalf of Elizabeth and I want to thank you for attending and for your questions and for your interest. And we look forward to continuing the conversation with you. Thank you.